Hello and welcome back to Civil Barrister with me, James Wilson from Park Square Barristers in Leeds. Today I'm talking to you about a case from the High Court, judgment handed down on the 14th of May. It's between Axa Insurance UK Ltd and EUI Ltd. It's a case about two conflicting insurance companies indemnifying one party, definition of social, domestic and pleasure purposes, and the definition of a private motor vehicle for the purposes of those insurance policies. It's a claim about two insurers arguing over to what extent they are required to indemnify one particular driver. It was a Part 8 proceedings issued by Axa Insurance seeking a declaration from the court. The brief facts are that Mr. X was the driver of a Vauxhall Astra at the time of a road traffic accident. That Vauxhall Astra was insured by the claimant in the case, Axa Insurance, and on the date in question, Mr. X was involved in a road traffic accident with Mr. Y. Mr. Y, it seems, was seriously injured by that road traffic accident. Liability for the accident is still an issue, as are the causation and extent of injuries, and so the details of the case as set down by the High Court are fairly narrow, so as to not prejudice the substantive personal injury proceedings. But the issue arose between the two insurers because the Vauxhall that Mr. X was driving was not his car. It was provided to him by a garage because his car was being repaired. He usually drove a Ford Focus. Now, the Vauxhall that he was driving was insured by Axa Insurance, and Mr. X's usual car, a Ford Focus, was insured by Elephant, underwritten by EUI Ltd, the defendant in these proceedings. So there are two policies which potentially cover Mr. X for the time period that he had the road traffic accident. Now, the issue was whether the trip that led to the accident was covered by both policies or just the policy given by AXA. So what was Mr. X doing on the night in question? This is important because it provides an important factual background from which the court had to interpret the specific terms of both insurance policies. So the night before the accident, Mr. X had been working as a security guard at a hotel in Birmingham. That wasn't his usual place of work. He was doing a favour for his manager, who was also the manager of this hotel that he was working at on this particular night. And the accident happened the morning after Mr. X's night shift. Additionally, on his way home, he had diverted to pick up a friend from a coach station, and he was going to drive them both back to Wolverhampton, drop his friend off at home, and then he was going home. So it's with that factual background that the court identified the two issues which it needed to determine. Was the use to which Mr. X put the Vauxhall at the time within the terms of the policy provided by Elephant, so provided by the policy for his personal car? And the second issue, was the Vauxhall properly to be described as a private motor vehicle? So those were the questions, and the contentions of the parties was therefore advanced under two heads. Was Mr. X using the Vauxhall Astra for the purposes which fell within the policy of Elephant, namely social, domestic and pleasure purposes only? And was he driving a private motor car as defined within the Elephant policy? In fact, the definition of private motor car in the Elephant policy required not only that the vehicle was designed solely for private use, but also that it should be privately owned. So there's two potential limitations under this second limb, and effectively three ways in which the policy or the cover by Elephant can be confined. So those questions needed to be answered with reference to the specific terms of the policy. Now I'm going to go through those terms and put them up on the screen. If you want to go fast forward straight to the conclusions of the court, then you need to go to about 11 minutes and 19, which will give you the court's decision. So obviously under the elephant policy, it's set out under section 4 of that policy when the driver is liable to other people. Section 1A of that was driving your own car, so driving Mr. X's Ford. But under 1B was the important section, driving other cars. So if you're 25 or over and qualify under the section, the cover is for the policyholder only and is third party only, while driving a private motor vehicle within the territorial limits. It says you will be covered for everything listed in clause 1A, which is if someone's killed or injured or damaged to property. When you are driving another car, as long as, then it lists the requirements. Certificate of motor insurance says so, hold a valid driving licence, but importantly, the other car is not owned by you, a rental car, nor hired to you under a hire purchase or leasing agreement, and you have the owner's permission to drive the car. The others are obviously valid insurance for that car, not covered by other insurance to drive it. You still have your car and it is not being damaged beyond repair, stolen nor sold. The certificate of motor insurance provided relevantly as follows. Section 6, limitations as to use for social, domestic and pleasure purposes only. Then the policyholder may also drive with the consent of the owner a private motor car not belonging to him or her and not hired to him or her under a hire purchase agreement. Policy does not cover use for merchandise delivery, renting out, peer-to-peer hire schemes, or use for hire and reward, included but not limited to taxiing and chauffeuring, etc. Consistently with this, the motor policy schedule attached to the elephant policy shows that the permitted use in the elephant policy was for social, domestic and pleasure purposes only. The definition section provided that a private motor car means a privately owned motor car manufactured to carry up to 8 passengers, which is designed solely for private use and has not been constructed or adapted to carry goods. So the elephant policy allowed the use of another car, but only if it was for some social, domestic and pleasure purposes, only if you had the permission of the owner of that car, and only if it was a private car, and only if it wasn't a hire or leased car. The Axa policy was provided by the garage and was insured and described as a commercial insurance road risk cover. So the motor certificate for the Axa car, for the car that the Mr. X was driving, provided that it covered any motor vehicle, the property of the policyholder or in the custody or control of the policyholder in connection with the business. Provided who could drive that motor vehicle, any person driving on the policyholder's order or with his permission, any person driving on the policyholder's order or with his permission whose vehicle is in custody or control of the policyholder for servicing or repairs. So those are the two policies. So under the arguments in relation to social, domestic and pleasure purposes, the argument put forward by Axa is that Elephant's policy expressly limits his cover to social, domestic and pleasure use. So Axa disputed that Mr. X was working. They argued that because he was doing a favour for his boss by working at the hotel, then that was not work. Alternatively, the term in the policy did not expressly exclude travel to and from work. And finally, the diversion to pick up his friend altered the nature of his journey from work to social, domestic and pleasure. Contrary to that, Elephant obviously submitted that as a matter of fact, Mr. X was working. He was driving home from work, whose car was being used to travel from home to his place of work and back again. So those were the arguments in relation to social, domestic and pleasure purposes. The arguments then moved on to whether it was a private motor vehicle. Axa submitted that a private motor car denoted a car that was not provided or owned by the state. So in Axa's definition, that policy covered all cars, whether individually or commercially owned. It said that the car met the definition of a private motor vehicle because it had not been adapted for commercial use and because it was owned by a garage and not a public entity. Axa pointed out that the terms of the policy lacked clarity, and in no circumstances the policy should be interpreted in favour of Axa. And lastly, if an insurer wished to exclude a specific cover, then it should do so clearly and explicitly. Contrary to that, and not unsurprising to you no doubt, Elephant argued that a private motor car plainly excludes courtesy cars owned by a commercial entity. The policy specifically excluded a rental car, so the policy therefore specifically excluded the car loaned to Mr. X by the garage. Elephant also submitted that the purpose of the driving other cars extension within its policy was to permit policyholders to drive a car belonging to a family member, friend or acquaintance, and was obviously not intended to cover those cases where a business lends or hires out a car. The court's findings then. The court assessed the journey in terms of its primary or essential primary purpose of the trip. It found that there was a journey home from work, that the detour did not affect that the car was Mr. X's means of getting to work and his only means of getting home. And it also found that the frequency or novelty of the work is irrelevant to whether Mr. X was factually working at all. Having decided that it was excluded under the social, domestic and pleasure purposes, the court needn't have gone on to deal with the issue of private motor vehicle, but it did. It found that the car cannot be described as a private motor vehicle. The car was part of the garage's business. It was an inducement to a customer to leave their car for repairs, so it was effectively a marketing tool. And the court also found that no doubt it was a tax-deductible business expense. So the option of a private motor vehicle, as referred to in the Elephant policy, was plainly not a car which was operated or supplied in the course of a business. The court dealt with some of Axa's arguments then. The court said there was no justification for the definition put forward by Axa, in that only cars not owned by public authorities are private cars. And for those reasons, the court ordered that Axa must bear the liability alone. Obviously, this was a case decided on its own facts, interpreting as it did the specific terms of an insurance policy. But the terms social, domestic and pleasure and private motor vehicle appear in almost all private motor vehicle insurance policies. And so it's important when looking at indemnity concerns to investigate the evidence surrounding the journey leading up to the index accident.